Hi, and welcome to The Brief. I'm Sanam Siddiqui, presenting to you the Brief News today. The Brief News today is about the recovery notices that have been sent to more than 50 people in Uttar Pradesh, to those protesters who were held accountable for damaging public property during these protests. Unilateral notices were issued for recovery of damages. This episode also talks about the 2009 Supreme Court guidelines as well as the 2010 Allahabad High Court ruling. The Allahabad High Court has asked the state government to satisfy it as to under what authority of law the recovery citation to the tune of Rs 64 lakh has been issued. Retired IPS officer Sarvan Ram Darapuri has filed a writ petition challenging the recovery citation. He has been accused of instigating violence during the protests which took place on the 19th of December 2019. He was arrested on the 20th of December but later released on bail. These recovery notices were issued in order to make up the losses caused to the state exchequer owing to arson and violence that took place during the Anti-Citizenship Amendment Act, that is, CAA protests. During the CAA protests, 22 people were killed in UP. Several bikes, cars, buses, police outposts, and other public as well as private properties were set ablaze and damaged. The first recovery notices went out in December of 2019 in Rampur, Sambhal, Bijnor, and Gorakhpur. The overall damage that has been assessed by the UP government has come to 1.56 crores. Darapuri has claimed in his petition that the recovery citation was issued in an illegal manner. He also alleged that there was no proof against him of inciting any violence. The bench also expressed its concern over the issuance of the recovery notice unilaterally and without issuing any notice. It has fixed the 14th of July as the next date of hearing. In 2009, the Supreme Court issued landmark guidelines in re destruction of public and private properties versus State of AP to curb arson, destruction of public and private property during political agitation. So in December of 2019, the UP government had directed the district magistrates to act in accordance with the High Court order, stating that loss should be recovered from political parties, organizations, or any individuals who had called for agitation or procession that led to violence, arson, or any type of damage to public properties. The district magistrates or the DMs were told to constitute teams under ADMs, assistant district magistrates, to evaluate property damaged in violence and to list out the people and the organizations that were responsible for the losses. The UP government had stated that these losses were to be recovered by auction of these people's properties. The UP government had also stated that the district magistrate is the competent authority to take action under the provisions of the Prevention of Damages to Public Property Act of 1984. The Prevention of Damage to Public Property Act of 1984 punishes anyone who commits mischief by doing any act in respect of any public property with a jail term of up to 5 years or a fine or both. This law can be applied along with the provisions under the Indian Penal Code, if applicable. These recovery notices mentioned a 2010 Allahabad High Court judgment in Mohammad Shujauddin versus the state of UP. This judgment issued guidelines for destruction of property during public agitations. A petition was filed in the Honorable Supreme Court of India in January this year against these notices. The petition alleged that the notices have been sent in an arbitrary manner. Some notices have been sent to people against whom there are no FIRs. Some notices have been sent to people who have not been booked under any criminal provision. There have been instances of 90-year-olds receiving notices. This petition argues that the notices slapped on the protesters was based on the 2010 Allahabad High Court judgment, which was in violation to the guidelines passed by the Honorable Supreme Court of India in 2009 and was later reaffirmed by a 2018 judgment. The 2009 Supreme Court judgment arose out of suo motu proceedings in 2007. The Honorable Supreme Court had taken cognizance of the large number of properties that were destroyed in the name of bands, hartals, agitations, and the like. The Supreme Court had formed two expert committees, one headed by a retired Supreme Court judge and one headed by a senior advocate, to suggest changes to the prevalent law. Both these committees submitted their reports, following which the Honorable Supreme Court issued guidelines in 2009. the committee headed by the ex-Supreme Court judge recommended reversing the burden of proof against the protesters. The Honorable Supreme Court bench accepted this recommendation and stated that the prosecution should be required to prove that public property had been damaged in direct action called by an organization, and the accused also participated in direct action. The Honorable Court stated that the burden was to be shifted to the accused to prove his innocence. The law must be amended, the court stated, to give the court the power to draw a presumption that the accused is guilty of destroying public property. It would then be open to the accused to rebut such a presumption. Generally, the law presumes that the accused is innocent until proven guilty. The second committee, headed by the senior advocate, dealt with extracting damages for destruction. The Honorable Supreme Court also accepted these suggestions and stated that the rioters should be made strictly liable for damages and compensation should be collected to make good the damage. The Honorable Supreme Court also stated that in the absence of a legislation, the High Court could take suo motu cognizance of any instance of mass destruction to property due to protests. The High Court was instructed to set up a machinery to investigate the damage caused and to award compensation. The judgment also stated that in case there is more than one state involved, action may be taken by the Supreme Court. Thus, apart from holding the rioters liable and awarding damages and costs, the Honorable Court also directed the High Courts to order suo motu action to set up a machinery to investigate and to award compensation wherever mass destruction was caused due to public riots. In such case, the High Court or the Supreme Court is required to appoint a sitting or retired High Court judge or district judge as a claims commissioner to estimate the damages and probe liability. The judgment further goes on to state that an assessor may also be appointed to assist the claims commissioner. The procedure laid down was such that this team could ask for video recordings from both private as well as public sources to examine the damage and identify the perpetrators. Liability would then be fixed on the perpetrators as well as the organizers of the event. The damages could be shared between the two as the court would decide. The claims commissioner would be expected to submit a report to the High Court or to the Supreme Court, which was to fix liability after hearing both the parties. These guidelines were to become inoperative only after a law was put in place by the states in line with these guidelines, or in case any other fast-track mechanism was created by law. On the other hand, the 2010 Allahabad High Court order had called out the UP government's complete apathy in implementing the provisions of the Prevention of Damage to Public Property Act of 1984. The court has scathingly observed that this was because such activities were usually led by political leaders and parties. In such cases, this judgment ordered that the owner of the damaged property is required to file a claim for realization of the amount from the political party or a sitting or former people's representative. It is to be expected that identification of protesters is a mammoth task, especially in those cases where there is no immediately identified leader who gave the call to protest. In February, the Allahabad High Court had stayed the recovery notice issued by the UP government to a Kanpur man seeking compensation for damage to public property. In March, the Allahabad High Court had stayed another recovery notice issued by the Bijnor ADM against 4 anti-CAA protesters. Both the notices were stayed on the ground that the issue is sub judice before the Supreme Court. However, as per HuffPost, the advocate for the UP government stated in the Allahabad High Court that because the Supreme Court has not stopped it from issuing the recovery notices, therefore, the UP government has continued to send recovery notices to other people accused of damaging property. Darapuri maintains that he did not join the anti-CAA protests on the 19th of December because the UP government had imposed a curfew in the city and placed him under house arrest. Per HuffPost also reported on the 10th of July. Now, the government's case is that everybody should obtain a stay order on their own. And if they don't obtain a stay order on their own, we will impose recoveries. Now, everyone has to run to court. And many of these people are very poor and they can't go to court. This article quoted a senior advocate in Lucknow who is representing activist Sadaf Jafar, who is also a former teacher and a Congress member, and who was also visited by police and revenue officials last week. Sadaf Jafar was released on bail in the first week of January 2020 after having spent 20 days in jail. Recently, the UP government sent her a notice demanding compensation of 64 lakhs in lieu of damage to public property caused by her. If not paid, the administration will attach her property. Jafar has been named in 4 FIRs and is facing nearly 40 cases, including under Section 307, which is attempt to murder, and under various sections of the IPC. She was also one of those 50 that were named and shamed in those now infamous hoardings that the UP government had put up. The Allahabad High Court had directed the District Magistrate and Commissioner of Lucknow to ensure removal of these hoardings and to file a compliance report by the 6th of March 2020. These hoardings had photographs, names, and even addresses of those people accused of vandalism during this anti-CAA protests. The ex-IPS officer had filed a writ petition to stay the 17th of February order in the Lucknow bench of the Allahabad High Court in March. But due to the coronavirus, the first hearing was only held on the 17th of June.
Darapuri told HuffPost,
the lawyer who appeared for the state government asked the court for 10 days to respond, but the next day, the activist was served with the latest recovery order dated 12th of June, which said that failure to comply could lead to sealing the house or arrest.
On the 18th of June, Darapuri received
RC Form 36 of the Revenue Code, which invoked Section 143(3) of the Code and ordered him to pay 64.37 lakhs in damages within 7 days, or state his reasons for failing to do so. If not, his house could be sealed and he could be arrested. However, Darapuri's lawyer states that there is no Section 143(3) in the Revenue Code, and RC Form 36 is sent pursuant to Section 141, subsection 3, that gives a person 15 days and not 7 to respond. While 28 people, including Darapuri, Jafar, and other activists in Lucknow, have been held accountable for more than 60 lakhs worth of damage to property. However, they have each individually received notices for the entire amount. The UP Recovery of Damage to Public and Private Property Ordinance was promulgated on the 15th of March, and it allows for the setting up of a 2-member claims tribunal comprising a retired district judge and an administrative officer of the rank of additional commissioner. This claims tribunal will assess the damage caused to public and private property during the anti-CAA riots and award compensation to the owner. This ordinance also says that if respondents fail to appear before a tribunal, it will conduct the hearing in their absence, attach their property, and can also publish their name, photo, and address for the public not to purchase property from them. Referring to Section 28(2) of the ordinance, the advocate for Darapuri had said there's a provision that says if any action has been taken under the government orders issued earlier, then it will be deemed that the action has been taken under the ordinance. He goes on to state that they will probably rely upon that to say that the orders that the ADM has signed stands protected. In another petition filed on the 17th of March, a Lucknow-based collective of human rights lawyers and activists say that the ordinance is arbitrary and unconstitutional because it allows the state to act against whom there is no prima facie evidence. The petition states that the laws for recovering property, the Code of Criminal Procedure 1973, and the Prevention of Damage to Public Property 1984 already exist, and that this ordinance is also in violation of the 2009 Supreme Court order. The petition states that it's inconstitutional as setting up of a tribunal with multiple members and functioning even with a single judicial member and several non-judicial members is not permissible in law as laid down by the Supreme Court in Roger Matthew versus South Indian Bank Limited. The petition goes on to state that the appointment of the non-judicial members in the tribunal is unconstitutional because there is no special expertise required from non-judicial members. Thus, it states that only tribunals with judges would be permissible if such tribunals were constitutional in the first place. Another petition filed on the 17th of March by an Allahabad-based advocate states that the ordinance violates the fundamental rights guaranteed in Part 3 of the Constitution. Thank you for watching. If you like this video, please click on the subscribe button below. Following which, generally the law prescribes that the accused is guilty, dealt with extracting damage. The 2009 Supreme Court judgment arose out of suo motu proceedings in 2017.